next case is State of Ohio versus Thomas Lee Ellis. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
I'd like to reserve 5 minutes for rebuttal, please. Thank you, Your Honors. May it please the Court. My name is Attorney Wesley Buchanan. I have the privilege to represent Thomas Lee Ellis III, the appellant in this matter. As indicated, we'd like to reserve 5 minutes for rebuttal. At the outset, Thomas will note that he did testify in his own defense, and in addition, Thomas understands that on the insufficiency analysis, the evidence is taken in a light most favorable to the government. In addition, Thomas understands that circumstantial evidence may be given the same weight as direct evidence, and that the trier of fact is free to believe some, all, or none of a person's testimony. The facts of this case are that there was an incident on September 4th that was testified to by Ms. Fraser, who was not a victim, but was a testifying witness, that her and the decedent got into an argument. They got into an argument, she ran away, and witnesses saw her running away very scantily clad. 4 days later, she returns to the decedent's house on Bradley Street in Akron. No running water in the basement. They have to shower on the 3rd floor. And in addition to that, what happens on September 8th is why we're here. On September 8th, Fraser and the decedent get into an argument. The testimony reveals that after they get into an argument, they leave the basement of the house and then they take the fight to the streets. After that occurs, during that fight though, both the decedent and Fraser had been using alcohol and methamphetamines, which was testified to. After they take the fight into the streets, Thomas enters the picture. You see Fraser leaving the scene, and then Thomas encounters the decedent. Thomas testified in his own defense that he sees the decedent approaching him, and he uses the term charging him with his hand in his pocket. Thomas then produces a firearm and discharges the firearm 9 times, and the decedent passes away. Subsequently,
Counsel, where did he strike the body?
he struck the body, I believe, in the midsection.
Front, back?
Front. And that's what, if memory serves from the transcript, I believe that's what was testified to. Again, this is Thomas's testimony. At the result of the jury trial, the jury was instructed on self-defense, and the jury returned verdicts against Thomas for murder and not any of the lesser included, which supports the claim for the ineffective assistance of counsel. With that said, Fraser did testify that she didn't hear anything prior to the shooting or prior to the gun being discharged or anything of that nature. So Thomas was the one that was primarily testifying there. Colorful language was used in addition to the decedent charging Thomas from his point of view, including an F-bomb. I believe the government's brief asterisked that out, but I won't repeat it here for the court. So the court was instructed, the jury was instructed on self-defense, and Thomas understands that an insufficiency analysis, the Ohio Supreme Court has said that the self-defense is not analyzed under an insufficiency analysis. That was a case that the Ohio Supreme Court came up with. However, it can be analyzed under the manifest weight section of Thomas's error. And so this court, sitting as the 13th juror under manifest weight, taking into consideration the credibility of the witnesses and everything else like that, the fact that Thomas did testify to some very personal experiences as to the reasons why he engaged, to why he thought it was self-defense, and to why the situation occurred. Those were very personal details that involved abuse when he was a child. And that's very, very soul-bearing when someone says that. But however, the jury did not believe him ultimately. With the credibility of Frazier, obviously she was using methamphetamines in the transcript. It was indicated that the defense team didn't have the opportunity to speak to Frazier prior to her testimony, which was brought up at the trial court level. I believe the court did permit some conversations there. So Thomas's point of view here is that he was defending himself, and that is why this court should reverse his convictions and set this matter back for a new trial. And without the court having any other questions, Tom?
I have a question. Regarding the third assignment error on the ineffective assistance of counsel regarding manslaughter, did trial counsel elicit testimony that would allow the court to give a manslaughter instruction had one been asked for?
So under voluntary manslaughter, the burden would be that sudden fit of passion or rage. And so the testimony from Thomas when he was under direct and cross-examined was that he was angry, and that he had this passion of rage because he is recalling his previous experience as a child being abused, and then seeing somebody not be stepped up, and then he steps up, and that can at least have the inference, at least for a jury instruction. Whether or not the trial court was going to give it or not, obviously is speculative.
So, I guess because of the other assignments of error on sufficiency and this not being a Messner issue with manifest weight because it's the mens rea, it sounds like during those arguments, and it might not be true, I haven't read the transcript yet, it sounds like all of those things were couched within self-defense, reasons why he was afraid and he needed to defend himself or others, as opposed to reasons why he didn't have the requisite mens rea for the charge of which he was charged.
Correct, and that would be supported by the transcript both during Thomas's testimony and then Frazier's testimony as well about what was going on. I mean, she was the eyewitness and she did testify to the drug use and everything else like that. And then when Thomas testified, he was describing these very personal and deep experiences when he was a child and everything else like that, saying, listen, you know, there was this event 4 days ago. I know what it's like to be in the streets. I know what it's like not to have somebody step up for you. I know what it's like to be, you know, this kind of a downtrodden person. You know, and then, you know, you see a scantily clad woman in her bra and panties trucking down the street in the area. That's leaves an impression. And then 4 days later, you know, that goes to there. So it not only goes to the mens rea, but it also goes to the, as the court indicated, this is why I felt threatened of fear of my life, which is an element of self-defense. Does that answer the court's question?
It does, thank you.
And with that, Thomas will remain the time for his rebuttal for 5 minutes, if there are no other questions for the panel. Thank you.
Good morning again. I'm Rick Raley on behalf of Summit County Prosecutor Elliot Kolkovich and the appellee of the state of Ohio. I will address the manifest weight primarily, since it sounds as though the sufficiency assignment of error has been conceded this morning. Now, I think there's plenty of evidence in the record for this jury to have rejected the defendant's self-defense claim. I would say that there are 3 other witnesses in the record who contradict his own testimony about whether there was a verbal altercation before the gunshots went out. He was asserting that he was also protecting this Miss Frazier, who's indicated in the record, but she was walking on the opposite side of the street and further ahead of the victim who was shot. The victim was unarmed, and he was shot when he was more than 5 feet away from the defendant, which is what he's testified to. The autopsy report was put into evidence, and it indicated that there were gunshot wounds to his front, and there's an entrance wound to the back of his left upper leg. So there are gunshots going through multiple parts of his body on both sides. No gun was recovered from the victim at the scene. Now, I think that's pretty easy for this court to reject that manifest weight argument because of that in the record. And just in regards to the ineffective assistance, I think it's well settled that the failure to request certain jury instructions on lesser included is a matter of trial tactics that's within trial counsel's purview. In this case, they went for a full acquittal based on self-defense, which the jury decided to reject. I would think even if there was a request for one, it'd be inappropriate. First of all, there's a lot of case law that says self-defense and voluntary manslaughter are incompatible. I'd also point out that this altercation 4 days before, if that was some sort of a motivating factor for why he did what he did, there's a sufficient cooling off period there to end any possibility for voluntary manslaughter instruction. So with that, I'd ask that you affirm the convictions. Thank you.
You'll have your full 5 minutes for rebuttal.
Thank you, Your Honors. May it please the court. Thomas would indicate that he's not conceding the insufficiency analysis. It's just that this court is required to look at the self-defense claim under the manifest weight, and that's where the Ohio Supreme Court has landed. So Thomas would at least indicate that for the record. In addition, as far as the jury instructions are concerned and the ability to have evidence of voluntary manslaughter or involuntary manslaughter, recently this court issued an opinion in State v. Kennard. It was not cited in the brief, but it did not have a problem with murder and voluntary manslaughter. So as far as the instruction is concerned, going to that, that's certainly something to consider for this court. Again, this is a situation where Thomas was where he was in the community that he was with the situation that he was. Sadly, the decedent perished. However, Thomas believes that he was acting in self-defense, and that is why, as this court, sitting as a 13th juror, should find that this is the rare case and this is a miscarriage of justice, and remand this back to the trial court and order a new trial. And the panel does not have any other questions. Thomas thanks the panel for its time and appreciates the reversal forthcoming. Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a written decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the Supreme Court of Ohio posts the decision on its website. Thank you again for your presentation.